Good morning. Welcome to the ninth session. I can't believe this is the ninth session of Your Morning Briefing, a monthly webinar series designed to keep you informed and ahead of the curve on labor and employment topics, all in the time it takes to finish your morning cup of coffee. I'm Anna McCarthy, and I'm joined by guest host, Ben Mudrick.
Hi, I'm Ben Mudrick. I get to work with Anna.
And I get to work with Ben. Today's morning briefing is going to cover the many changes we've seen in the federal government's enforcement priorities with respect to issues related to employment law since the beginning of the Trump administration. So it's only been a couple of months, but we've seen some really drastic sea changes to federal enforcement priorities. And we're going to go over some of those today, some of the federal agency changes. But because we're only with you for 30 minutes, we're just going to give a brief overview of some of the more important points, especially some specific points for employers, and then some suggested action steps for employers to consider. But before we get started, I just want to cover a few housekeeping items. This webinar has been approved for a half credit of HRCI and SHRM and CLE credit as well, and we'll give some instructions for how to submit that later. This webinar is intended for general information purposes only and should not be considered as legal advice, even though Ben and I are attorneys and speaking to you. And all participants' lines are going to be placed on mute. So if you have any questions, technical or content related, just send a message via the Q&A widget on your toolbar. Don't use the raise hand feature because we won't be able to see that. We will try and address your questions as we go. But if we have a couple minutes at the end, we'll address questions then as well. So Ben, where are we starting?
Yeah, well, it's great to be here. When the election happened last year, I think we all expected big changes, but in previous webinars we've talked about this, the changes have really come fast and furious and have been even more severe than maybe we expected. So a big one that just happened recently was the EEOC and the Department of Justice put out a joint press release about DEI-related discrimination. The EEOC's new priority is to really focus on DEI-related policies, programs, and initiatives under federal law. The memo provides some explanation on federal government's definition of DEI, this is their focus. Their view is that these types of programs are oftentimes in violation of the law, which we may disagree with on some points, but we'll have to see how it goes. So the key point is that Title VII prohibits discrimination based on race, religion, national origin, sex, and other statuses. And the point of view from the EEOC is that any decision based on these statuses, whether it's trying to remedy a past harm or trying to do what the employer thinks is right or trying to increase diversity, that any actions motivated in part or in whole by any of these statuses is unlawful. So it's really not about whether you have good or bad intentions. They say if you consider race or religion or sex, then that's problematic. DEI initiatives, so the memo goes into specific initiatives that they think can be problematic. So the initiatives that they say may violate the law would be things like excluding certain groups from fellowships, internships, summer associate programs, maybe scholarships. And it's not just excluding certain groups, but only allowing certain groups to participate. Also, they specifically referenced employee resource groups, that limiting memberships in these groups can be problematic, potentially under the law. DEI training itself can constitute a hostile work environment, according to this memo. So, you have to think about the training programs that you give and what, whether the things that are being taught in those training programs potentially could be viewed as problematic. And also that retaliation in response to reasonable opposition to training can be a violation of the law. So if an employee says, hey, I think that training was racist, if you take negative action against them, that could be problematic under this memo. Again, remember, this is just a memo. This is just the EEOC and the Department of Labor saying, we think these things may be problematic. It doesn't necessarily have the force of law, but they would potentially sue an employer or investigate an employer about these things. And we'd have to see kind of how that would end up. Look, I'm not, I think this is a very strong approach that they're taking. But if you had called Anna or me a year ago and they said, hey, we want to create a ERG group for this certain, for employees in this certain category, and we don't want to allow anyone else to participate, I think under the law, we would have said, look, that's risky. That's potentially problematic. But now we can see that the EEOC is going to kind of focus on that a little bit more. The memo also makes clear that customer client preference or your business interest isn't a defense to these. So if you have customers saying, hey, we want to see more diversity, we think you should hire more people from this certain group, that's not going to be a defense. Now, that's always been the law as well. We've had examples where customers have complained about Muslim employees wearing a headscarf or something like that. And we've told them, you can't discriminate just because that's what the customer wants. It's the same principle, but again, they don't care about your intent or whether you're trying to address a wrong or something of that sort. Again, the EEOC in this memo, interestingly, points out, this idea is we always thought there would be more reverse discrimination claims because of this.
Mm-hmm.
The EEOC has said, we don't think reverse discrimination is a thing. We just think any discrimination is prohibited. So, I mean, it's kind of an interesting way to look at it, but the EEOC is taking this position that everyone is protected, not just minority groups. Everyone's protected under Title VII, and that's always been the law. The issue is that it's always been a little bit harder under the legal standard to prove discrimination if you're not part of a minority group. So the EEOC has said that their position is there's no different standard. Now, there's a case at the Supreme Court right now that's looking at that exact same issue. So we'll see how that turns out. I suspect it'll probably end up similar to where the EEOC is, but keep that in mind. And that's always been the case. And when we do trainings about harassment and discrimination, we've always said to employers, look, every employee has rights. Every employee should be in a workplace that's protected and that's respectful to them. So look, we think the EEOC is taking a harder line position, and this may result in more claims from employees who are not part of minority groups. But every employee has rights, and that's just something we all need to remember as we do investigations, as we do trainings, and just got to keep that in mind. Even more is going on at the EEOC other than just this memo, though. So Anna's going to talk about that.
Yeah, so a lot of those enforcement priorities that you're talking about have come from acting chair Andrea Lucas. So she was appointed acting chair when President Trump took office. And he also fired 2 Democratic members of the EEOC commission. So now we just have one commissioner left, Kalpana Kodagal, who was designated by President Biden. So she's a Democratic member, and we have the acting chair, Andrea Lucas. But that leaves us with 3 vacancies, which means we don't currently have a quorum, and the EEOC is limited with respect to what they can do without a quorum. So certainly some types of litigation may be able to move forward, but we might not see high profile litigation from the EEOC or major policy changes without a quorum. So that does put a little bit of a damper on their activities, but it certainly doesn't mean they can't issue guidance like what you were just talking about, Ben. So another thing we've seen is that some of the regional office activities have changed. So we've seen some EEOC lawsuits involving the rights of transgender individuals being dropped because of this administration's position on the fact that their position is sex is a binary concept, and that Title VII in federal law does not protect gender identity, gender expression. So that does open up a little bit of a conflict between federal law and state law that we'll talk about in a second.
And the Supreme Court.
And the Supreme Court, frankly, when they expanded Title VII protections to sexual orientation with the Bostock decision. So certainly, you're absolutely right, Ben, there's a lot of conflict here. It doesn't necessarily mean that this conflict is new. We've always had conflicts between New York state law and federal law, other state laws, New York state law and federal law. So there have always been differences in the way that employers need to comply in various states, but these differences have sort of been brought into more stark relief with the fact that this administration has been very active through executive orders in announcing their priorities. One other note to mention for the attorneys on the call, there was a recent executive order from March 22nd that directs the Attorney General to recommend when an attorney in litigation against the federal government warrants sanctions or other disciplinary action. So that the focus of that executive order seemed to be more about immigration cases, but litigation against the federal government could include litigation against the EEOC. So certainly something to keep an eye on, although it doesn't really say anything more than sanctions under current federal law and other disciplinary action. So in terms of next steps, take a look at your DEI programs and policies. Make sure they're compliant with current federal law, current state law. This may also be the year to consider doing a new training. It doesn't mean that you need to change the topics that you address, but it does mean you need to be thoughtful about the way that you're presenting the training, and also thoughtful about responding to employee complaints. If you get an employee complaint, you need to make sure that you're giving that complaint time to, or that employee time to voice their opinion, whether or not you agree with it, and look into that complaint to see if there's anything you can do to address it. I'll say one more thing about the state and federal law conflicts that we're seeing here. So this has, particularly in New York State, I think been a topic of discussion because of the fact that we've had a lot of longstanding protections in New York State that do seem to be in conflict with federal law. So more recently, we saw February 13th guidance from 16 state attorneys general, including our New York State Attorney General, regarding DEI policies and programs. So it's interesting, this guidance had a list of what the states considered to be lawful DEI practices, which seems to be a little bit in conflict with the list of what the EEOC is now considering potentially unlawful DEI activities. So some of the lawful DEI activities from the state's perspectives are things like trainings, equal access to employee resource groups, which is not necessarily in conflict with the federal perspective, because equal access could include access to anybody that wants to join an employee resource group, like you were just saying, Ben. So again, I think there's some nuance here, and there's certainly going to be a difference in perspective, but there's a path forward here for employers. It just may require a little bit of careful navigation. The other couple of things that have been that are potentially in conflict with the federal perspective are New York State's current sexual harassment training and model sexual harassment policy, which does include references to gender identity, to pronoun usage. That certainly seems to be in conflict with the recent executive order in which the president mandated that federal agencies recognize that sex is a binary concept. So certainly a potential conflict here. You may see some issues with certain types of requests for accommodation from employees being in conflict with other employees' perspectives or views. It doesn't mean that one person is absolutely right over the other, but again, it does mean you have to think carefully about addressing everyone's concerns and at least listening to the employee complaint, again, even if you don't agree with it. Ben?
I'm an employee. I go to HR and say, look, I think the sexual harassment training and discussion about pronouns is an affront to my religious beliefs. I don't want to participate. New York law says that you have to do sexual harassment training every year.
Right.
Federal law says you have to accommodate religious employees, or you can't, under this guidance, your training could be a violation of something. I don't think our training is, or most of them would be. How, Anna, would you react to an employee who comes to you if you were in HR saying, I refuse to participate in the training. I think it's illegal or inappropriate or harassing to me?
Yeah, it's a great question, because certainly we've seen this scenario happen already, and I think it invites more risk, even more risk now, given the federal administration's position. So I think the first step is you can't just dismiss that complaint outright. You have to take the time to listen to the employee, to listen to their perspective, and see what they're asking you to do. They may just be complaining, but maybe they have a specific ask, and maybe it's something you can address. That being said, you don't need to provide an accommodation if it would cause an undue hardship to your business. There are certain analyses you have to walk through, as you know, for religious accommodations and other types of accommodations, but you are not under an absolute obligation as the employer to accommodate everything that an employee brings to you. But I think the first step is certainly just to listen to the employee and see if there's a way to address it. It may end up just being a personnel issue. Certainly, you can have a perspective on pronoun usage, but when it crosses over into being unable to work with your colleagues, that could be problematic. So definitely, again, some issues for employers to navigate. There may not be one correct answer for every situation, but I think, again, they're navigable issues.
Yeah, I think, and it's going to be different for every employer, and it's going to be different for every employee you talk to. I think, like you said, listen to your employees, listen to what their concerns are, see if you can resolve them. And then the thing I always say is, after you listen to them and talk to them, send them an email to follow up on the discussion, so you can document that you had the discussion and that there was some sort of agreement. Because if you write back to the employee and say, hey, this is what we agreed on, we're going to, you have to do the training, but you can leave 10 minutes early before we get to this section, or whatever it is, put that in writing and make sure the employee confirms that they're okay with that path. That way you have a defense to show that you actually did work with them on the issue.
Yeah, absolutely. Document. So we're going to move on to some Department of Labor issues. So moving on from the EEOC now to Department of Labor. So Ben, what's been going on there?
Yeah, look, this is less exciting than what we were talking about before. But again, something that happens every administration is the test about whether somebody's an independent contractor or an employee changes. Under Democratic administrations, they tend to be more strict and they adopt more specific tests about whether you're an employee or an independent contractor. They focus on things like the economic realities, who's making decisions about tools, when they show up. Do you have your own clients? Can you work for other people? And under Republican administrations, it tends to shift back to a more general test about who has control over the relationship. So again, the moment Trump was elected, again, this isn't very exciting, but we all looked at each other and said, well, we're going back to the old test, which you probably get a lot of articles from law firms and SHRM saying, oh, new independent contractor test. I've been practicing law for a long time. In my feeling, probably shouldn't say this. I don't think it matters that much, especially for those in New York and California and Massachusetts. The tests are different at the state level. They're more employee friendly. So again, it's something to look at. If you do use independent contractors regularly, or you have somebody on your sales team come in and say, hey, can we just hire this one person as an independent contractor? It'll solve a lot of problems. Just remember that whatever the test is, you've got to be careful on this one because the damages can add up quickly. It can be problematic and can turn into a workers' comp issue, a tax issue. So again, I don't think the test is super important. If you have questions, we're happy to talk about that. But the real thing is remember that there is a test and you can't just make people contractors all the time. Even under the Trump administration, they're not still gonna make it super easy.
Right.
And if you have questions about that, obviously reach out. Now, I don't know if this is exciting either, but we're going to talk about the National Labor Relations Board now.
Well, before we get to that, I just want to make one more note about Department of Labor activities. So this is going to be a little bit of a callback to the program that we did on February 12th when we talked about some of the, at that time, more recent executive orders regarding DEI, regarding federal agency activities, and specifically the OFCCP. So if you're a federal contractor, listen up. If you're not, you can tune out for about a minute or two. So back in February, we talked about the fact that the OFCCP enforcement priorities were going to shift pretty radically. And now if you're a federal contractor, you have about a month now until April 20th to cease activities regarding your affirmative action plans related to race and sex. So not only are you not required to do those anymore, you're not allowed to do those anymore as federal contractors. You do still have to move forward with your plans regarding individuals with disabilities and veterans. And we'll see, actually just yesterday, the USDOL appointed an attorney from Morgan Lewis to lead the OFCCP. So we were seeing a little bit of a vacuum for a while there where there was no head of the OFCCP. The website of the for the OFCCP had really been scrubbed of a lot of resources that we were used to seeing, but those might start being added back to the website, or we may see some more guidance about how to move forward. So for those of you, especially those of you on a financial year, you may be starting to think about creating your affirmative action plans again this year. So again, it's just for individuals with disabilities and veterans. We may see, now that we have a head of the OSCCP, some more guidance coming out regarding their activities. For now, though, a lot of the audits and investigations had been halted, so we were just not seeing a lot of activity. We'll start to see some more now, I think, with the new head being appointed just yesterday. So now, Ben, you mentioned the NLRB, and I cut you off. So
No,
what are we going to talk about?
I was supposed to talk about that last thing, and Anna's such a pro. She just covered it. So thank you. Yeah, the NLRB, for those, the National Labor Relations Board, this is the introduction every time there's a law about unionization and what employees can do. It's one of those things that most employers don't think about very often, but over the last few years, the NLRB has kind of raised its status, and we've had to think a lot about the NLRB because they don't just protect union rights. It's about workplace activity rights and working with each other, talking about wages, that sort of thing.
So even if you're not unionized, this is important.
Exactly. I think a few years ago, some guidance went out about handbooks and what you can and can't have in a handbook. And, when we first read that guidance, we thought, oh my gosh, this is crazy. You couldn't have a policy that said you need to be respectful of your coworkers because that potentially violated with rights. We're kind of in that same situation now. So just to back up, the NLRB has it's the National Labor Relations Board. So there's a board that kind of oversees these things. They make decisions about labor law related issues. When Trump was elected, he removed one of the members, which brought the board below the 3-member quorum. There can be 5 members. There were 3 at the time. He fired Gwen Wilcox, so it was down to 2, which meant there wasn't a quorum and they couldn't make any decisions.
Mm-hmm.
Now, Gwen Wilcox challenged that decision in court, and she's actually been reinstated to the National Labor Relations Board.
Mm-hmm.
So there is a quorum again, but it's kind of up in the air. We don't really know what's going to happen next. But that could be appealed. But for now, the NLRB is intact. And again, like the EEOC, the NLRB has started to take actions to kind of direct its local offices and kind of give us a preview of which way they're going to go when they make decisions in the future.
Right. And just anecdotally, the regional offices have been quite busy because of a lot of the changes at the board level. And I think there's just been a lot of sort of scrambling to make sure that normal activities continue, even if maybe they're a little bit slower than we're used to seeing. So just a lot of changes. And again, the regional office point here, same with the EEOC, there's a head of the EEOC and a head of the NLRB. There's their commissioners or chairs, but then they have regional offices to sort of keep them apprised of what's going on across the country. They can't have their hands in everything. So these regional offices really drive the local activity, local enforcement of the federal agency's priorities. So we've always seen differences between the way certain regions handle things. One regional director may have a different perspective than another when it comes to how often and how proactive they're being about looking into certain things. So I don't think that's going to change. So not regardless of the board priorities, but I think we're going to see some differences in the way that regional offices are handling the direction from the board, and same with the EEOC. So with respect to board guidance, we saw a lot of changes last month in February when the NLRB acting general counsel, William Cowan, issued a memo GC 2505, which rescinded a number of previously issued memos. Now, this is not unusual when there is a new general counsel, which was expected with the Trump administration, as happened with the Biden administration. They do sometimes pull back the guidance that was issued with the previous administration because their priorities are going to be different. So with acting GC Cowan, he rescinded, it was quite a long list of memos that Jennifer Abruzzo, the GC under Biden, had issued, and she was particularly active as a GC. Yes. That was a little more unusual. She was quite proactive about issuing guidance. A lot of it was rooted in case law, but we saw her sort of go beyond case law and issue opinions on things like non-competes, for example. So over the last few years, we've talked a lot about her guidance memorandums and how employers can navigate them. And now it seems that all of our advice was for not. No, I'm kidding. I'm being a little facetious here, because even though some of these memos have been rescinded, the underlying case law for now is still good. Yeah. So we may see the board, the new board, overturn a previous board decision. We may see a circuit court decide differently, or a district court decide differently than we saw during the Biden administration. But it sort of remains to be seen what case law will change. But for now, the memos that Jennifer Abruzzo had issued, a lot of those, again, are rescinded, including a memo that was very strict about handbook rules, and the fact that, to your point, you couldn't have policies that even had a whiff of potential. I was in the middle of talking about the rescinded NLRB guidance. One of the other decisions, or one of the other memos that Jennifer Abruzzo had issued, was with respect to employee communications, confidentiality, non-disparagement clauses. Now, that's all rooted in the McLaren-McComb decision. So that decision hasn't changed, but the guidance that really took it a step further and said, you can't have certain types of non-disparagement provisions. You really can't limit too much what employees can say with respect to confidentiality provisions. That memo has been rescinded. So some of the protective language we had been inserting into separation agreements, into settlement agreements, that may change now. It doesn't mean that protections for employees have pulled back under case law, but it certainly does mean we don't have to be quite as meticulous about certain of those provisions like we were before.
Yeah,
So
I think the way that plays out, if you reached out to one of us in the last couple of years,
right.
and you said, "Hey, I need a settlement agreement or a separation agreement, and I needed to have a confidentiality provision or non-disparagement provision. I don't want anybody to be able to say anything," and we'd say, "Okay, but," and then you'd read it and it would say, "You can't say anything about this except," and there's this paragraph about all the exceptions to it. The general principle, like Anna, still exists, right? There are limitations on confidentiality, non-disparagement, but we can refine that language, we think, and I think that's important. So just don't use the same, if you're going to do a separation agreement, be thoughtful about using the document that your attorney gave you 12 months ago or 2 years ago.
Right.
There may be ways to make things a little bit more protective for you and your company.
And it definitely doesn't mean that the document that you currently have is unusable.
Yeah.
It just means that you may be able to pull back a little bit on some of the provisions. So I don't know if we'll be able to take a look at your questions because of the technical difficulty that we had, but for those of you who need credit, I just want to make sure that we get those codes to you. So you'll see the codes appear, I believe, on your screen. If you don't, I'm going to read them to you. So no worries either way. The CLE code is Agency 25. That's AGENCY 25. That's for CLE credit. If you would like HRCI credit for this webinar, the activity ID number is 701371. 701371. That's the HRCI activity ID. And the SHRM code is 25-3ZXV as in Victor A. 25-3ZXV as in Victor A. So you can enter those into their respective portals to submit for credit. And again, I don't know if we'll be able to take a look at your questions. I apologize for that. If you do have any questions from this webinar, feel free to email Ben or myself. We're happy to discuss any of these points with you, particularly as Ben, as you mentioned, if we've talked about any of these topics with you over the last few years, certainly you've seen that some perspectives have changed. So if you're wondering how to be in compliance now with some of these issues related to DEI, your separation agreements, board protections related to unionization, feel free to reach out. We're happy to talk anytime. And just a reminder that we'll have Your Morning Briefing session next month. If you have any questions about today's webinar or you have suggestions for our next webinar, please feel free to reach out to us directly and keep an eye out for an email regarding our next scheduled date and topic. And thanks again to everyone for attending. We really appreciate you joining us today.